Oh, good evening. Good evening, everyone. Welcome to Dean Rod Vera's copyright question and answer or FAQ session, where I will answer or maybe in the first discuss copyright law, both in the Philippine and in the US setting. Uh, right now, I have two people online. Welcome on board. So let's see here. I'm on time. And okay, all right. Introduce myself. I am Dean Rod Vera. I am a law professor, law school dean. As part of academically, that's what I am. But in practice, I'm an intellectual property lawyer. Um, I have a master's in intellectual property from the University of San Francisco School of Law. And the Bay Area in California is the hotbed of intellectual property, which is just a short drive away from Silicon Valley. And some noted intellectual property law firms and companies are based in the San Francisco Bay Area. All right. Um, okay. So, what is copyright? Copyright is a branch of intellectual property law. There are three branches. There's copyright, there's trademarks, and there's patents. Um, Copyright is technically a realm of protection or protection status given to works or articles that are in the literary or artistic realm. And these works are manifested or created or present in mediums of expression which are developed now, and both American and Philippine law describe it as have mediums which will be later developed. For example, there are certain mediums right now, electronic mediums, which were not present back in the 50s, the 60s, or even the 70s. And so, if a work today was created digitally, such as the YouTube videos and the digital pictures, they were not thought of or they were not invented back then in the 70s or even 80s. So, meaning the law is progressive and looking forward in the sense that even though when the law was created in the 70s or 80s, anything created now will still be considered protected by copyright law. Hello. Oh, we have a couple of. Good evening, Kurt, GB, and Kin. Good evening. Okay, so continue with the lecture. So copyright is under the realm of intellectual property. Now, why is it called intellectual property? First, it's intellectual because it is created by the creative mind, and at the same time, it is only perceived intellectually, meaning there are no physical, well, not most, are they have no physical manifestation or physical characteristics, such as a song, uh, or like a movie. There's no permanent fixation of the movie except either, especially now, there's only digital. And then it is property because it is subject to ownership and exclusion, and that is what property is all about. Property are uh, objects which somebody can own and exclude others from using it or allow people to use that property, such as your phone, your house, your car, which, as you know, have physical manifestations. For us, copyright, you know, um, I may own the song as a composer, but you have a copy of the CD. So there is there is a difference between the copyright and the material object. So even if you have the CD or the book or the movie, the DVD, or even an authorized digital copy, the owner of that copyrighted work can prevent you from exploiting it or making money out of it. That's the essence of property. Such as, you can't borrow my car without my permission, and you can't make money out of that car. Let's say you want to use it for a grab or maybe even a taxi. So that's the nature why. copyright, insofar as literary or artistic works, is considered property, and it's intellectual because it's both created and perceived basically intellectually rather than physically on a philosophical or theoretical level, not necessarily on a real level. The only possible artwork that is permanently fixed is paintings and sculptures. Those are once created, they're a one-off. I mean, there's only one painting, there's only one sculpture or original painting. Okay, so that's the nature of copyright. Now, how is that protected? How can one protect? Now, as you know, when you protect property, you either put your name on it, you exclude others from using it. You put it, let's say for this ball pen, you put it in your bag, you put it in your pencil case, or you keep it from others. In that sense, that's what also you do with copyright. If you written a book, if you written a story, a poem, or even a song, you keep it to yourself. You put it in you record it on your phone, or record it somewhere else, or you type it in a Word document and you save it in your computer. That you created. Now, you protect it by not let anybody seeing it. No one can see it. It's secret. But once it's out there, once it's out in the open, can you still protect it? Yes. If you satisfy the copyright requirements, by law, the law will protect you in going after those people who are using it without your permission. You can file cases for infringement, but we'll go on that later. No? Okay. Oh, hello, your game. I've answered a couple of your questions on the comment section. Alan Gutierrez, what IPL books do you recommend for a law student? What's interesting question. There's two books I would recommend. One is by Attorney Salau, and one is I have one copy here. This book is by my good friend Judge Rosil Tambasakan. So this is the intellectual property book, Intellectual Property Code Simplified. This is a good book. It's illustrative of. It shows a lot of the cases as of 2018. So that's a good book to follow. Going back to copyright, let's see now. So how is a copyright protected? How is an owner protected? Okay, first, you have to prove creation, meaning the law says as of now, and also in the U.S. and here in Philippines, is that copyright protection starts from the moment of its creation, meaning once it is created, by law, it is already protected by copyright law, by copyright. Of course, if it's out in the open, how do you prove it's yours? That's what it means. You have to prove that you can prove the moment of creation you made that literary or artistic works. Back in the day, it would be very hard, but today, in the digital age, it's easy. When you take a picture through your phone, you can look at the metadata of the picture. When you create a Word document, maybe a story, you wrote a poem, you wrote it in your computer, you save it as a file. Therefore, it's first saved, it's manifest is present in your computer, so you can prove, hey, I made this file on March 7, 2021 at 7 p.m. There's a digital footprint for that work. So back in the day, one would have to prove it otherwise in other ways. One of the methods, although it's not definitive, it's only what they call prima facie or valid on its face or it's rebuttable, is you file for, at that time, copyright registration to the proper authorities. For the US, it's filing it to the Library of Congress. For the Philippines, it's registering it with the National Library. But today's law, and also the US law, it is not necessarily definitive proof of ownership, only proof of registration. Again, copyright is protected from the moment of its inception or creation, and one has to prove that. Now, to file or to register it, what's called deposit, to deposit in the National Library in the Philippines, shows that there's a government document showing that you've deposited such work with them, and that is what they call prima facie proof of ownership, which means it's rebuttable. Okay. So going with protection now, Um, Copyright law is unique in the sense that um, there are only three rights technically available under copyright law. Now, what is a right now for those who are law students or just any follower of the law? A right is when you impose your will against somebody else. For example, when you impose free speech, you're forcing it on the government or another person to make you to have them listen to what you have to say or allow you to say what you want to say. So the three rights under the copyright law is only three or are only three. The first one is to carry out. You have the right to carry out, which means you perform acts on those works for yourself. You have the right to authorize, meaning you have the right to allow people to use it, or in the copyright world, it's called license. You give license to people to use the works. And the last right is to prevent. You can stop people from using your work or making money out of your work. Now, what the law says under Section 177 of the Intellectual Property Code for the Philippines is that the copyright is equated or given a synonymous word as economic rights. So, what are economic rights? These are the acts or the powers or how a work is exploited. And again, these exploitative acts can be carried out, authorized, and restricted or prevented by the copyright owner. The first act or economic act is reproduction or copying. The second one is the economic act of derivative, meaning a copyright owner has the power to make a book into a movie or a song into a movie. That's called derivative works. When you change the work, you adapt it. You make it a different form, yet it's the same story, or it's the same work it's the same work in essence. The third economic act that a copyright owner can carry out, authorize, or prevent is distribution. The fourth is rental. The fifth is display. The sixth is public performance. And the law provides this in number 7 of 177, other communication. It is worded that way so that it is progressive in the sense that it can be interpreted or it can be used in future forms of exploitation for the work. So the old notion was when you display a work, it is displayed physically. If you display a painting physically, or perform means you perform it live, for if it's a song, or through either a band or an orchestra or by oneself. So the other communication now can be interpreted as, for example, now YouTube or other forms of digital performances or digital outlays, such as converting a music file into an MP3, so it can be played through your phone. Right now, it's wireless through your Spotify and other or iTunes, other audio companies. So these economic rights or economic acts or acts of exploitation are controlled through either authorization, prevention, or self execution or self when they carry out by the copyright owner. Now, what can a copyright owner do? Well, it's up to him to protect, because copyright law and intellectual property law, for that matter, is or are private rights, meaning the government does not do it for you. You have to do it yourself. So if you see somebody using your work without your permission, you can't take the law into your own hands, but you have to go to the courts, file an infringement lawsuit, file a TRO, temporary restraining order, or an injunction to prevent others from using it. But of course, before that, you can always send them a letter, send them what they call a cease and desist or a warning letter. Please stop using my work. Please, or stop using my work altogether, because if you don't stop, I will sue you. So it's a demand letter or a warning letter. That's how one can control. So other than protection, now copyright. How long is the copyright protection? In the Philippines, um, a simple math would be that it is the lifetime of the author, not owner, author of the work, plus 50 years. So, for example, one of the great composers is John Lennon from the Beatles, and he passed away in 1980. So theoretically, his work, whatever he created, is his or his estates or Yoko Ono's until 2030. What happens then? When a copyright, when a electronic artistic work no longer has protection through the will of the owner or by the expression of its protection, or for failure to protect it in other instances, it is then what they call part of the public domain, meaning anybody is free to exploit such work without fear of infringement. So, again, one of the ways that a copyright loses its protection is 50 years after the passing of the author. In the US, depending on when it was created, it can go either 75, sometimes even 90 years after the creator passes away. So you have to remember, it's not the owner of the creator. So how's that? What do you mean by that? So an author of a copyrighted work, or literary artistic work, is the one who made it, and that can never change. That is forever there. It's a lifetime title, if you will. But again, as I said a while ago, you can create the work, but it can be sold, meaning the right over that work can be sold. A perfect example of that was back in the 80s. For those who are, well, I'll give a more relevant example. But one of the more famous examples back then was Michael Jackson, through a company, bought or owned more than half of the song of the Beatles. So even though he didn't compose the songs, he basically owned it on paper. Another example of that, and those who are, I think, who are more familiar with the times, is Taylor Swift. I think a few years ago, Taylor Swift's songs were owned by her manager for some, under some weird contract agreement, or how they signed it. And so, even though she was the composer, the songs, when it was recorded, what they call the master tapes, was owned by, I think, either her manager or the record company. So what she did, I think, although I'm not a Taylor Swift fan, I think it was either resolved or she was going to re-record her music, and therefore she would own the masters. How's that play? Well, example. So when a song is recorded in a studio, back then, time of your parents or your grandparents, a song was recorded and placed in master tapes. It's a magnetic type of film, or let's call it tape, and that's where the original recording stays. And from the master, it then can be transferred into cassettes, CDs, or vinyl records. Although today there's no physical masters, but people now record digitally. But although there is a drive right now, there's a move to going back to analog or tapes. So when a band or a musician goes to a recording studio and his songs are in the masters, usually the producers get to own the masters. The artist owns the songs, but the producer owns the masters, and that's where the producer's rights are born out of. Producers can control how the masters, its version, are played. So that's why the songs from the 70s and the 80s and maybe in the 90s, although the artists are known for those singing that, for composing it, they may be technically owned by the record company. Well, let's not go into that. That's too much of a turf war. I don't want to get into. I was into that for a while. I did help some bands get back their songs, but so far, those that I worked with, we had some success. But right now, because of these new mediums, artists today, musicians rather have more control over the music. So that's one thing. All right, let's see what have questions here. All right, Mr. Game. Attorney, is the concept of fair use policy agreeable with our IPC? We cannot use mainstream media news clips not uploaded on YouTube for content due to copyright. All right, now that's a very touchy issue. If you're using it just for YouTube, at itself, you cannot use other people's work. Okay, first, but let me get it straight. So the primary thing is when somebody has his own work, whether it be a newsreel or his own video, and you want to use it in your video, for example, your question is a YouTube. That means you're getting somebody else's creative work, somebody else's hard work into your video. So you are borrowing his work without permission and putting it in your video, in your own video. Is it fair use? Now, the concept of fair use is that philosophically, since copyright owners can exploit basically everything about what they created, their work, their artistic work, the government says, well, you're not totally in control. There are ways where somebody else can use it fairly, hence the word fair use. So one example is using it for news. If you are giving in the news of the day, you can use somebody else's work to show, hey, this is news. So that's another fair use. Now let's go back to fair use. Now there are 4 or 6 ways for fair use to happen. No? Meaning it's fair use means that you are borrowing or using somebody else's work without permission, and then using it as part of your own content or your own work. You can use it. So the law says you're allowed to use it if it's for criticism, for comment, for teaching, for scientific or scholarly research, and for news reporting as well. So meaning you have to make the work that you're using, the borrowed work, so to speak, as the subject matter of your own content. You're criticizing it, you're giving a comment, you're making part of news, or you're teaching about it. That is allowed under our law. If you're going to use it for your own exploitative methods, then that's not technically fair use. So if you're going to use it without permission, you have to defend it in the ways of fair use. Now, if you want to look in particular how fair use is explained and used, you can go to section 185 of the Philippine Intellectual Property Code. All right. Oh, we have a question here from Sherwin. All right, here we go. If the music catalog is sold, does artist lose his royalty to those songs? All right, here's the nitty-gritty about it. There is no law on royalty. There is none. The law does not mandate royalty. What the law actually mandates is that you can prevent or authorize somebody from using your music or using your work. Hence, when you license it out or you authorize somebody from using it, of course you want some money back for it. You know, it's like when you rent a car, you pay to borrow the car. In essence, a royalty is, in effect, a payment or a fee for the other person to use the economic acts which I illustrated a while ago. Copying, using, rental, displaying, or performing. Now, does the artist lose his royalty? It all depends on the contractual agreement of the artist. Let's say author. Because usually it begins with the author. The author makes the work, And when he makes the work, does he sell automatically his work to the producer or anybody else, or does he retain the copyright and then he lets other people use it or borrow it? So if in the contract that this author, let's for example, Blue Records, if the artist named Mr. Sports Law, Mr. Sports Law made a song, and he's the record company's Blue Records, and Blue Records, let's say, pays him let's say $100 a month for his songs to be played on the radio, and Blue Records was bought out by Green Bar Records. Green Bar Records, theoretically, hypothetically, will have to respect the agreement between Blue and the author, and so that's how the royalty is protected. So that's, yes, without any knowing the contract. So yes, the royalty will still be respected if the contract is there, unless Blue Records bought out the artist. So if he bought it out, if now Blue Records owns the song, then there is no royalty for it. All right. Okay. I hope that answers your question, Sherwin. All right. Let's go to Odessa Fonda. Good evening. Thank you very much. I appreciate Miss Odessa. All right. So let's go back to copyright law, the lecture. Let's call it the lecture. One of the aspects, let's go to the uniqueness or the unique parts of copyright law. First, not all things can be protected, even though you put your blood, sweat, and tears into it. That's why there's what they call the sweat of the brow doctrine, the eyebrow. Meaning, even if you put hard effort into something, if the law says it can't be protected, then it doesn't matter. For example, facts. Facts are never protected. Okay. Another thing is that people have rights over expressions of an idea, not the idea itself. So, for example, the idea of a boy falling in love with a girl and they get married is basically almost all love stories. That's the idea. No one can exploit or protect or monopolize that idea. But the way it is expressed, rich boy, poor girl, or a local boy, foreigner girl, all this other all idea way to express a love story, you are protect a author, whether a screenwriter or a book author. The unique story is given protection. For example, a young boy wizard, you can't get a protection on the young wizard. But if somebody was a young wizard whose parents were murdered and goes to a wizarding school, see, then that uniqueness, that expression of a young wizard, then will get protected. So that's why J.K. Rowling owns all the rights over Harry Potter, over the Harry Potter world. All right. That's the uniqueness of copyright law. So now, again, facts are not protected. Rules are not protected. I mean, because there's only there's only so little ways to write rules. I mean, if you change the rules and the rules are changed, it makes up different rules. There's a case. It's called the merger doctrine, wherein if there are only so little or limited numbers of ways to express the idea of the rules, then there will be no more protection because there's only little ways to express the idea. Now, there is a contradiction here with regards to music. I'm sort of a musician myself, but I'm not that very good. A musical scale only has 7 notes, and a piano only has 88 keys or 88 notes. It's the same 7 notes, or just repeated in different pitches, or high or low. And so, if you think about it, if you only have 7 notes in a scale, how many ways can you manipulate it, or how many ways can you exploit it? Actually, until it's limited because of the certain pitches or octaves. So, in a sense, even though there's a limited number per se, such as 88 keys or 7 notes in a scale, its melodies are practically endless. So that is why music even though it's just a play of seven notes, different melody, different timing, it'll change. That's why music, even though, as I said, is practically endless. So there's many ways to express, sorry, excuse me, music. Another what uniqueness of copyright laws, at least for the Philippines, is that the government technically cannot be considered. Uh, well, no, they can. If the government makes a work, it is not given protection. First, in essence, a government is not there to make money. A government is not a business. A government is there to provide services for its people. So when a government makes a speech to its people, or the government creates laws which are written words, but technically they are artistic works or literary works. These laws, speeches, or anything made by the government cannot have copyright protection. But still, if you want to use it and borrow it, you have to ask permission. But meaning, if you use it privately or for school or whatever, you don't have to you don't have to ask permission. Then again, a government that acquires copyrighted works, then can exploit it. So again, the government cannot be authors or authors that are given protection, but they can be owners of copyrighted works. So, for example, the National Museum, when the National Museum buys a painting or buys works, they own it, but it is still copyrighted, meaning it has protection, but it wasn't made by the government. So hopefully I explained that properly. If not, just tell me questions and I will try to explain it. Good evening, June. Welcome to the live copyright lecture. All right. So those are the unique parts of copyright law. Maybe we can go into its specifics, if you will. So um, first, since more of you are on board, just let me introduce myself again. Um, oh, hi, Chan. Okay. Oh, you're very welcome. You're very welcome. Um, I am attorney Rod Vera. Well, Dean Vera. I'm a dean of the University of Caloocan City College of Law. Um, I have a master's of intellectual property law from the University of San Francisco, and I'd like to quell the rumors. People think I'm an entertaining lawyer. No, no, no. I'm an entertainment lawyer. So there's a big difference. All right. Part of, let's say, my roster or my qualifications to be, aside from having the degree in intellectual property, for the last maybe 15 years, I've been a lawyer for several artists, for several musicians, bands. Currently, I'm part of the board of the Movie Workers Welfare Fund, or MOWEL Fund. I am part of the board of the Performers Rights Society of the Philippines. I have been legal counsel to the Actors Guild, um, and I have currently I'm also part of the creative team of TBA Studios. Um, this is the film company that made Luna and Goyo and Write About Love. So that's my qualification. So in a sense, uh, my my practice, if you will, is centered on copyright law. So I have some experience in dealing with artists, producers, and the government with regards to um, copyright. Hello, Aaron Aquino. Good evening. Welcome on board. All right. Let's see here. Okay, let's get see my notes. Okay, all right. Uh, you're welcome. Thank you very much. Your kind words, Mr. John. Thank you very much. All right. Now, so let's go back again to those who are came just now. So copyright again is protection given to literary and artistic works which are protected from the moment of creation, and an and although that's given as property, it is property because it has the essence of ownership and exploitation and exclusion, meaning you an owner of the copyright can do whatever he wants with it, make money out of it, prevent others from using it. Same time, he can make money out of it by allowing other people uh, to exploit it or make money out of it. So again, a copyright owner, whether it be author or owner, has the power to carry out, do things by themselves, to authorize or license, and to prevent or to have everybody stop from doing it. And what can they authorize, carry out, and prevent? The economic rights are reproduction or copying, derivative, distribution, rental, display, performance, and other communication to the public. All right. All right. Let's see here. Now, in a copyright, it is its term of protection for those who came on board is only was not only it's 50 years from the lifetime or after the death of the author, not the owner, the author. Okay, all right. And so, as I said, the example a while ago was John Lennon, who passed away in 1980. So his works have protection only until 2030. Now, a work or copyright work, once it expires in its lifetime, the expiration date, or for some reason the owner declared it with no protection, then that work is considered part of the public domain. When it becomes part of the public domain, it is then uh, free for anyone to use. So, for example, the works of Mozart, both Beethoven, Bach, Brahms, these Tchaikovsky, all these composers who passed away long ago, their works, if you're able to get a copy of their musical notes, you can make your own versions of it. Put it up in YouTube if you want. You play your own music, play your own instruments, and you will not get any copyright notices about it. All right. Okay, so let's see here. Copyright law. After, so once, other than economic rights, a author has moral rights. Moral rights are different because theoretically there's no money out of it. One of the moral rights given to authors, not owners, is the authorship, meaning he can force people using that work to put his name as an author. And in the reverse, he can have his name taken out of that work in case he doesn't like to be his name associated with it. Another more important part of moral rights is that a author who maintains his moral rights can withhold it from publication at any stage. Well, it's going to be very difficult, but technically that is available to him. Now, the unique part of moral rights is that the author of the work, his moral rights will be with him or her forever. It is not subject of change of ownership, meaning it may be waived, but it cannot be lost. Meaning it is with the author forever. It's up to him to choose whether he will invoke such moral rights. They're very few and far in between, but I was giving advice to a producer before who made a movie, and his director wanted to stop and invoke his moral rights. I told that producer, well, technically he can, he just can't afford to do it because when you file for an injunction or try to stop something, you have to file a bond to do it. Oh, we have a couple of questions. All right. Some suggestions. Someday make specific cases discuss IP applications. All right. Okay. How about if the problem is the books? All right. So for SE cases uh, for copyright. All right. Let me put up the list of cases here. Hold on. All right. The unique cases of copyright law. Um, all right. One of the unique cases of copyright law is that there is no, um, it's the case of the TV show, and it involved uh, a dating game show, and somebody tried to copy the dating game show, and according to those rules, um, the the show itself is copyrighted, meaning it is protection, but not the format of the show. Meaning, if you have a show about a dating game with a computer, somebody else can make that same format, because as long if that's the idea, as long as he expresses differently, then it can happen. All right. Oh, Sophia, Daddy Clark, good evening. Uh, all right, let's see here. Kenneth, if the problem is in the book, especially status of teachers making modules, take it from other books. Ah, all right. Kenneth, if it's teaching, okay, just remember if you're asking me a specific question about a specific and actual scenario, I have to first disclaim that what I'm saying is not legal advice per se. I'm answering questions as part of education and part of telling what the law is, rather than what how it can be done. So let's go to your question now. Teaching and books and modules by itself, uh, as I said, under fair use. Fair use is when a work is used fairly. It's redundant in a way, yes. So if teaching is one of the exceptions in the IP code, IP law, or copyright law, meaning if you get somebody else's work, somebody else's book like this, and start teaching it, reciting it in class, uh, or making it in a play, but it's manuscript, if it's in a teaching mode, by itself is not infringing, is not violating the copyright law. So that is the essence there. Now, can a book publisher go after a teacher? If the teacher is using it other than teaching, then maybe. Right? Oh, Sophia, let's see a question. Good evening. Want to clarify something? Oh, patent. Oh, okay. This is copyright law, but let's see here. If an inventor sold this patent to another entity or a company, will the inventor completely lose his rights of the patent? Now, Sophia, your question, Harry has the answer in itself. If the inventor sold his patent to the company, then it's like he sold his car, he sold his house, he sold his cell phone. He can't get it back. As long as the contract of sale or assignment is valid and nothing's wrong with it as a contract, then if he sold it for the right price, then he practically he lost it, all his rights. So that's, again, this is just part of education. It's not necessarily legal advice. You know, okay, here we go. Does an IP lawyer earn more than a regular litigator? Is it more lucrative than other specialization? Asking for a friend. Sure, Aaron. Is it more lucrative? Hard to say. Um, if you are working for the other side, the producers, the big record companies, the big tech companies, then maybe. But I chose myself to go for the artists, the stakeholders, the authors, and um, in that sense, I'm more of a fighter for them. So is it lucrative? Well, yes, if the you get the right paying client. All right. Sophia, you're very welcome. Okay. Okay, credit to the owner. Can I use the defensive infringement? Okay. So, Mr. Game or Miss Game, If you use somebody else's work and you put as a disclaimer, credit to the owner, all right, that is a bit confusing because under Section 184 of the IP Code, there are certain instances where you can be exempted or pardoned, if you will, or not subject to infringement. If you do it in such a manner that is allowed, and then still you have to give credit. This photo, this work is owned by so and so person. That if you putting it credit to the owner and it's under the lists of activities that under Section 184, then it is an exemption to infringement. Necessarily, if it's for YouTube, yes and no. Some authors only one credit, and then that gives an excuse. But by itself, your game, it does not excuse a copyright infringement. All right. So that's I'm sorry to say that is the um, that's the bad part of the copyright law, and so far as exemptions. All right. So let's see here. This is the book that I recommend. Let's see what else of the cases we can talk about. All right. All right. Here we go. Where's the copyright law? All right. Okay. All right. One of the cases that, as I going back to uh, things that are protected by copyright. Now there is although it's a U.S. case, it's the case of Brandier versus Cascade Pacific. It's not a U.S. Supreme Court case, but it's just a federal appeals case. Nevertheless, it's a very good standing. It's very well. It's very leading. Not leading. It's a very landmark case in a sense that even if you make a work, artistic or literary work, let's say artistic, but it has some utility wherein it um, it poses some uniqueness. It is, or in a sense, patentable. Then that work cannot have copyright protection because if it's under patent law, it is utility, it has a use, then that work cannot get copyright protection. What happened in Brandier case was somebody, a sculpture, an artist made sculpture, metal sculpture, if you like the bike rack, this wave motion, and it was a bike rack. So when somebody started copying it, he sued for copyright infringement for copying. He lost because the court said what you did is not copyrightable. It's under patent law. But since you did not get patent protection, you cannot protect it by copyright. So in that sense, it is what they call the useful article doctrine. If a work has some utility, then it cannot be subject to copyright protection. But there's an exception, and it's called the Danicola test. As a backgrounder, back in the early 2000s, whoever the examiner was, one of the questions in the bar exam was, what is the Danicola test? I have some problem with that because first, the Danicola test is only a law school article, and it was a footnote or a mention in the case of Brandier, which is not even a U.S. Supreme Court case. And in the Philippines, foreign cases are only persuasive, not necessarily jurisprudence. But yet, it was answered in the bar exam. Thing is, it's a U.S. case, and I'm sure not all IP professors thought this case. When that happened, I made sure that's always part of my syllabus. And the exemption to the useful article doctrine is that if the artwork and the utility can be separated, meaning the utility and artwork, even though it's in the same the same work, can conceptually be separated, then you can get copyright over the artistic component of such work or article. For example, a coffee cup. If you put some design in the coffee cup in itself is not protected, but the work or the artwork in the coffee cup can be protected. All right. Aaron, follow-up question. All right. Can an IP lawyer in the Philippines represent an international client? This requires some additional qualifications to litigate before a foreign court of IP cases. Ozio, that's two questions. Can an IP lawyer in the Philippines represent an international client here? Of course. Does it require some sort of additional qualification to litigate in the foreign court cases? Not necessarily. If the case is in arbitration, then you don't. As long as the two litigants have submitted themselves to arbitration, and then it's not necessarily a court of law. It is subject to a private agreement or it's a private court, if you will. And let me just do some humble brag, if I may. I actually was part of international arbitration a few years ago. Actually, it's about 10 years ago. And humility is just being humble here, and well, it's quite a long time. I am the first Philippine IP lawyer to successfully defend a internet domain case under the arbitration of the World Intellectual Property Office, or WIPO. Although it's public, it's more than 10 years. The case is sulit. What happened was there was this classified site 10 years ago called sulit.com.ph. My client owned sulit.ph. And it was an internet domain case. So sulit.com.ph tried to sue my client, sulit.ph, and to take over and claim the URL, the www.sulit.ph. That case was under the arbitration internationally, and my client won. So sulit.com.ph, all I'm saying, changed its name to something else. So that's all I can say. All right. Okay. Okay, going back to Aaron. Can requirement, as I said, I represented a Philippine client in an international arbitration. That is allowed. All right, your game. You've learned. You're very welcome. You're very welcome. Game. Right. So let's go back to other important cases. All right. Let's see here. All right. Now, under fair use, let's go back here. Let's see. It's pardon me for this, no, so that I'll be very careful about it. All right. Now, fair use. All right. So, fair use, this is an exemption to copyright. There's a lot of questions about fair use. Is that a person may use another person's work without permission if it's used for criticism, comment, news reporting, teaching, research, and scholarship. So meaning, if the use by the alleged infringer is commenting or criticism, then it is by itself fair, but it has to pass 4 factors. The purpose and the character of the use, the nature of the copyright of the work, the amount used by the alleged infringer, and the effect of the fair use versus the original work. So these 4 factors, somebody has to weigh, is it for the alleged infringer or is it for the owner? And if you win 3 out of 4, it doesn't matter. All you have to lose 1. So in a way, it's almost unanimous. If you lose 1 of the 4 factors, then it's not fair use. So technically you have to win all. Is that right? Yeah, that's right. All right. Good evening, Flores. Flores, good evening. Sir Damon, thank you very much. Good evening. Aaron, you are very welcome. Right. All right. So that's the fair use. There's a very famous case, although It's back in 1994. It is when Two Live Crew, probably no one's been born who's watching knows that group. They tried to they sought permission from the Roy Orbison to use the song Pretty Woman under a rap version, if you will. And they sought permission, and Roy Orbison said, no, I don't want. But they still want to do it anyway. So Roy Orbison sued Two Live Crew, and I don't agree with it, but Two Live Crew was exempted or was allowed fair use because they were commenting or criticizing the work and making it a parody. So technically, it is a parody defense using fair use. Does it work here? As of today, there is no actual case uh, interpreting the fair use doctrine. Although fair use is law in our country and also in the US, has it been tested here? Not fully. It's been cited, but and it's been given some credence, but not tested in a way. All right. A game. That's what you can do. I know you've subscribed. All you need to do is probably just keep watching the new videos every time I post it. And if you can, game, the videos that you think are relevant to your channel or relevant to your friends, you can just share it. I would greatly appreciate that. Uh, Liking my videos also helps. I think there's this thing called the YouTube algorithm, and by sharing, by liking, what YouTube does, it gives my it spams other people my videos. It shows up in their YouTube page or YouTube scrolling page, and the more people see, the more my channel can grow. And if you can do that, you game. I very appreciate it, Mr. Few of my students are watching. I to those who are my students, both in the two schools, I purposely made copyright law now after we made part of our lesson, so that oh my God, now you can use what I said in the midterm exam. Oh, that means I have to change it. Nevertheless, um, it's my advocacy. I'm here to educate people on IP law. All right. So let's see here. All right. Excuse me while I look into the law. All right. So now let's go with ownership of copyright. So I said, so going back now, the rule of ownership of copyright. The general rule, the basic rule, is that um, the author is the owner of the work or the owner of the copyright. That's the first base or the first instance. He can sell it, he can license it out, and so those are two things. It's property, just like your ball pen or your book or your car, your house. You own it, and you can sell it, or you can rent it out, but you still own it. Now, there are certain instances wherein there is a different nature as to the author and how it's treated. The first uniqueness is in joint ownership. Now, in joint ownership, the rule is without any agreement between the authors is fair share. If there's three, everybody owns a third. If there's two, it's half. It's four of you. It's everybody gets a fourth. But if there's any agreement, then whatever agreement you have. If let's say I own three, even over two of us or two people made the work, if I get to say I own 9, 10, you own 10, if you agreed on that, then that's the ownership scheme, so to speak. So the second part is that if it's separated or can be separated, then you get to own what is yours. So, for example, the old Broadway or West End shows of Andrew Lloyd Webber and Tim Rice. I think one wrote the lyrics and one wrote the melody. So if you can separate that, then you have copyright over the work, but you own the work, you own the lyrics, and you own the melody. But on the other hand, some of the Beatles songs, the authors are just Lennon McCartney. So meaning we don't know who actually wrote the lyrics, we don't know who actually wrote the melody. Just the composer is Lennon McCartney. So by law, it's half half. But we all know that some songs were written by John and some songs were written by Paul. It's just they still listed it as Lennon McCartney. So that's their decision to do that. All right. Another unique part of ownership is um, when a author is um, under a commissioned work, meaning he is paid to make that work specifically. He was hired by commission to make a work. What are the rules there? Without any agreement, is that the work, if it's a sculpture or a painting, it is owned by the one who uh, paid for it or commissioned it in a way, or the commissioner. Without any agreement, but the author or the painter, the sculptor, gets to own the copyright, meaning he can exploit it as a copyright, but the thing itself, the physical or material object that was made, is owned, or even a song is owned by the one who paid for it. So without an agreement. So that's why if you come across that, to make sure that you should have an agreement to make sure that both parties are treated fairly. In the last aspect of not that second to last is what they call if the work is part of a job, or somebody made work, somebody made a literary artistic piece of work, and he's employed. The way to settle that is to look how or when it was done. If the work was created as part of his job, then that work belongs to the employer. For example, if I work for Hallmark and I write poems that will be put into the Hallmark cards or the greeting cards, then whatever I make will be owned by the company because I specifically employed to write those poems. Now, if in that same Hallmark greeting card company, the accountant wrote a song, the accountant gets to own the work because his job was not to be artistic output for the card company or greeting card company. So that's it. So it is what your job is. If you're hired to write, make stuff, then it's owned by the employer. Another unique part of the law of IP code is when it's an audiovisual work or a movie or audiovisual. And here is that the copyright will be split into the producer, the author of the scenario, probably the script writer, the composer of the music if there is any, the film director, and the author of the work so adapted. So meaning a movie by itself without any agreement is going to be split into the producer, the author of the scenario, the composer, and the film director, and the author of the work. The author of the scenario could be the production designer. And so, in a sense, the law provides protection for those people who make these movies, who make the films. I don't think you don't call them film anymore because technically there's no film. Everything's digital. All right. All right. Okay. We're talking about fair use, production. Uh, all right. Moral rights. Okay. Um, the IP code or US IP code. Oh, we have a couple of questions. Okay. John Morlow. Is that like the wine? Merlot? Good PM. Good evening. If a music producer fails to follow his obligations in a perpetual publishing contract with the songwriter, will this cancel the contract and the publishing claim to the song? Okay, all right. I'm going to answer this hypothetically, and I don't know if it's I don't know if it's an actual case, so I'm not giving legal advice. Um, if a publisher fails follows obligations under the contract with the songwriter, will this cancel the contract and publishing claim to the song? Well, that is the case of Jose Marichan versus Biennial Music. What happened there was it's a Philippine Supreme Court case. Jose Marichan dealt with Biennial Music, and technically, Binary Music owned the songs, the publishing rights, but they failed to perform their obligations for some reason or another. Jose Marichan sent them a termination notice, and then Jose Marichan worked with BMG. And then when BMG put out an album with the same songs, Bayanihan sued BMG, and they lost because even though the songs or the publishing was with Bayanihan, Jose Marichan, by saying you didn't fulfill your obligations and I'm sending you a termination notice, the court, in a way, in effect, tell them by terminating that contract, that publishing contract, status quo, meaning everything went back to Jose Marichan and he could legally work with BMG. So hopefully that case answers your question specifically. All right. Okay. John Lubatong. How about product manual, Dean? Is it copyrightable? All right. There is such a thing called the Weiss doctrine and the Morrissey doctrine. Production manuals, product manuals are basically facts and instructions. And under the law, unique instructions by itself cannot be, or procedures, if you will, cannot be copyrighted, because there's only so many ways that you can write or manifest or express the manual. I mean, if you can't reword, you can't redesign the rules. You can change the words, but necessarily it's still the same law. So yes and no. A product manual, if it has artwork, maybe yes, it can be protected, but by itself cannot be fully protected. So let's say yes and no. All right, John. Okay, let's see here. We have a good question. Can the songwriter file for damages in such a case? As I said, yes, we did. We have this. It's Bayanihan versus the BMG case. Let me get the citation here. If you're a law student, let's see here. Is it? My friend put it here. You did not. Oh, did that? Yeah. Okay, let me get the case for you. All right. But just no, you just look, Google it. Go to the Supreme Court. So it's Bayanihan versus BMG versus Bayanihan versus BMG. So that's one thing. And can a songwriter file damages? Well, as I said, in the Jose Marichan case, he sent a termination notice to the record company, and that then, when the contract is rescinded or terminated, his rights that were given to the Bayanihan Music record company reverted back to him. Can you file for damages? Well, yes. If under the rules of obligation and contracts, if a party is remiss in his obligation and then he is violating the tenor thereof, or he is in delay, if you will, you can ask for damages. But that's going to court. So hopefully that answers your question, John. If you have any other questions, I'll be willing. We have about a few people on board. Welcome again. Not again. Welcome, or those who have been here before. Welcome. If you have any questions, I can just read them carefully in the chat box. You might see a piano behind me. That's not me. I don't play piano. That's my son. I do play. If you can see here, that's what I play. I play some play some guitar. Well, not very good, but I do my best. Although one of my client or the band have one of the two best guitarists in the country. My client for the last 15 years. Razorback has been my client for 15 years now, and it's a super group composed of the guitar players are Tirso Ripoll and Manuel Legarda, and they're my friends, also my clients, and I think they're one of the two best guitarists in the country. But then, as a band, I don't think there are two in one band, two great guitarists. Okay, let's see here. Okay, let's see here. Obalde. Miss Ubalde. Good evening. All right. I hope this video we publish as yes. By later today, or if not tomorrow, it'll be part of my video library, if you will. So please, when you go to my channel, it'll be there, and you can just rewatch the video again and again. Although I thank you very much for doing that. Thank you very much. Miss Sherwin, let's see again. Thank you for organizing. All right. Oh, now, okay. So now, okay. That's a very good question. Very good question. Is a slogan that is made into a jingle copyrightable or trademark or both? The answer is both. The slogan can be interpreted as a trademark because it symbolizes the product or the goods of an enterprise or a company. And when you make that into a song is protected by copyright. So in essence, you can put a trademark line in a copyrightable song. So there, the answer is both. Your game, all right. Is it safe to assume that music covers made in YT are technically copyright infringers? Okay, all right. All right, here we go. When you say technically, let's not say infringers because infringers is a conclusion of law, meaning you're only an infringer if you are guilty of it by the court of law. So to rephrase your question, is it safe to assume that music covers in YT are technically copyright infringers? Hard to say. I would suspect that if you do a music cover without any knowledge, the first rule is that there was no permission. There was no license to do so. But if there's some production value into it, it's they recorded it, I'm gonna assume that it is with permission. But if somebody plays the song, he interprets the song with his own guitar, his own piano, it's not an infringer, but I would assume that there is no license for it. Will the song owner or the song copyright owner go after the one who put it on YouTube? Hard to say. I said it because it's a property right. It's a private right. It's up to the copyright owner to sue. All right. So hope that answers your question. It's up to the copyright owner to sue the alleged infringer. So it's all subjective in a way. All right. Okay, so let me continue on with some of the lecture. Now, aside from authors or creators, another aspect of copyright law is there are three other characters in the copyright world. Let's go first to broadcasting organizations. The law specifically says that broadcast organizations have some related rights, some protection, because these TV stations and networks, first of all, they do make their own copyright. They do make their own work. But if they are rebroadcasting, if they're putting up their own work, the movies, other television series, they have control over their own broadcast. Meaning, I think the news now is that certain shows of ABS-CBN will be aired in TV5. So meaning TV5 could not have aired by itself. They need to have permission. Now, of course, now it's under contract with ABS-CBN. So that is a rebroadcast. If 2 years, more than 6 years ago, I think, what was happening was the provincial buses were showing movies. Of course, it's a 4 or 5 hour ride. You must have watched a movie, right? So what the MTCRB did was they went after the bus companies because they were showing movies. And they're saying that technically it's a public viewing and they are subject to the MTCRB realm of power, if you will, the jurisdiction. So what do the buses do? They start showing television stations, because only ABS-CBN can control or GMA can control their rebroadcasting, and I don't think they're going to go after the buses. So that's broadcast organizations. The next line, it's a bit touchy though, are performers and producers. Now, performers are actors, singers, musicians, dancers, or other persons who act, sing, play, declaim, play in, or interpret, or otherwise perform the literary artistic works. And performers, as I'm part of, I said, as I'm part of the performers right side of the Philippines. Performers have related rights, not necessarily copyrights, but they have related rights under the copyright law. Meaning, by itself, what they're doing is they're hired to perform somebody else's work. So without their performance, without their participation, the work of that copyright author could not have been brought out. So in a sense, the law says we have to protect them as well. So that's why when you listen to music, there are performers there, the session artist, the guitarist, the drummer. When you watch a movie, it's those actors, you know. And um, when you watch a play, it's the actors in the performance also. So all this, as long as you perform the work, you consider a performer. Now the law provides some performers' rights. It's akin to the economic rights, meaning the the performers' rights. They can authorize the broadcasting of their work, the fixation. They can also authorize copies. But the hard part about that is once they authorize the fixation of their work in the movie or in the play or in the music recording, those rights are lost. The unique part of performers is under Section 206 of the IP Code. And to explain it simply, is that performers, if their work, whether it be in a movie or a song, is rebroadcast, like cable channels. Like say, for example, if you are in the Avengers movie, I wish I was, and then it was shown in the cable channel, HBO, if ever, technically HBO has to pay the performer a remuneration right. Let's call it royalty. And under the law, and this is the unique part of the IP code, the performer remuneration or performer's royalty is given with the only number in the IP code, meaning it's the only one with a fixed amount, because royalties are not fixed. It all depends on the agreement. But under 206 of the IP code, section 206, a performer is entitled to 5% of his original talent fee. If you look it up, section 206 of the IP code. So meaning it is the only fixed number allowed in the law, nothing else. No one's given a mandatory royalty except for performers. So I think one of the strongest IP or related rights owners are performers, because technically they can demand 5% of their talent fee when it's rebroadcast. Do they actually do it? Well, we're trying, but we don't collect 5%. It's too much. But we do work there is a international schedule of fees, and performers rely on section 206, and it's a right given to them under the law. And that's how, because some of these actors, musicians, when they make a song, they perform in a song before, it's a one-off thing. But the law saw to it that, hey, we should still support them. So 206 is a very relevant provision of law. All right, let's see here. Accessi. Okay, good evening. Good evening. I have seen several pages in Facebook selling access to compiled ebooks and audiobooks. Is this considered illegal distribution or violation of the law? Right. Yes and no. If the author authorized that ebook and it is through a legitimate publisher, such as Rex Bookstore or Vibal Publishing, and they do it electronically, then if that person sells those books or sells those ebooks, just like Amazon, you can buy books on Amazon and it's in your Kindle. Those are ebooks. That's allowed, and there's a year fee for that. If it's just Facebook selling access, well, what Facebook page is that? If it's by the publishing company, then it should be legal. If it's by some random guy or girl, then I would think that is not authorized. To say it's a violation, it all depends, but I would say it's not authorized. Mr. John, again, in music recording, I noticed that only the songwriter has publishing rights, but the music arranger seems to have never artistic rights to music arrangement. Very legal basis to this. All right. Music arranger could be considered the producer. So that's, of course, so that's a while ago. So there was the broadcast organizations, and then there's the performer. Another set of persons that have related rights are producers of sound recording. Don't think of the producer as the record company. Think of the producer like Quincy Jones and others, maybe the musical arranger, if you will. But if his title is musical arranger, then technically he's not a performer. He just fixes the songs. I'm assuming he's the producer. The producer is an owner of related rights under the IP code, and he can also claim royalty, if you will, under Section 209 in relation to the performer. So, meaning if a producer wants to get his remuneration, or let's say royalty, he has to do it with a performer. He cannot do it by himself. Under the law, Section 209, a producer and the performer must work together to claim that royalty from the broadcast or whoever performed the work. I hope that answers the question. All right. So if it's musical arranger, it's different from producer. If it's musical arranger by itself, then it's there's not really anything to that. Okay. All right. Let's hope. Excuse me, friends. Let me take a drink. Just sip, if you will. All right. I see we have a lot of people on here. If you have any questions, if any of my student wants to ask a question that might be in the midterms, please go ahead. Just remember, if you ask it here, it won't be asked in the midterm. Okay. All right. Well, that's the basics law. That's the basics of copyright law. There are more unique parts of it, but it won't affect. They're too specific in a way. I will talk about, if anybody, I think, in the benefit of some people, and those who want to upload videos such as I do. You always have to think of two things when you upload to YouTube. Well, three things, so to speak. So first is that YouTube is a avenue for you to. They're allowing me, to show my work, although it's just a lecture videos and all I have, tutorial videos, in YouTube, so other people may view it. So let's say I might have a video, and I give it to YouTube. Hey, YouTube, please show it to everybody else. So whoever has YouTube can see my work. So I'm allowing YouTube to show my work. It's not like I hired YouTube because there's no fee, but nevertheless, YouTube allowed it. Now, because I allowed YouTube under our license agreement, YouTube then is saying, okay, since you're giving it to me to show, anybody can view it. Anybody can technically embed my work, my videos in their work. So that's allowed there. Okay. Now, for my videos, since I'm a lawyer, I make sure that I put up my own work. And why do I do that? Because content creators can and will be subject to two types of copyright issues or copyright notifications, if you will. The first one is what they call a copyright claim. So meaning, and maybe some of you have it, is that if you receive a copyright claim, it means that you've used somebody else's work in your video, whether it be a photo, music, or even another video. You used it in your own content. And so the first owner, let's say the prior copyright owner, copyright owner number one, will say to YouTube, hey, Mr. Vera's videos has my music. I'm making a copyright claim on that video. So as to me, what happens to me? If I get a copyright claim, is it good or bad? It's both. It's good because if it's a copyright claim, the copyright owner of the song or music I use in my video is not blocking it, is not tearing it, it's not asking it to be put down. So at least my video will stay. It's bad because if I'm monetized or I'm making money out of the video, the one who filed that content claim or copyright claim can get a slice of pie, can get some part of my money. So if I'm earning, let's say, $1 per view, that person gets 50 cents or 70 cents. I only get $1 per view. That doesn't happen. I get maybe 1 cent per view, hopefully. So that's a content claim. Now, I've seen a video of a musician. Okay, before going that, now, how does that work? How does these record companies, these artists, know that you put up their music in your video? It's called the content ID. And YouTube has millions upon millions of data that the record companies give them, or record companies or whatever. And when you put up a video, they have this super duper algorithm or program that will see that if your content matches any of the people's content IDs which have been submitted to them, and there's a match. So, for example, I'll give you a very aggressive content claimer. Let's say the music of AC/DC, right? Uh, and if I show any of AC/DC songs in my videos, YouTube will tell AC/DC, hey, one of your songs is in Rod Vera's video. AC/DC now has the option to set a copyright claim on me. And so whatever I earn, he gets a share of that. So it's good because if you use somebody else's work, you should pay for it. So they get paid. It's not you're not paying for it by itself. You don't put out any cash. But if you are earning, instead of getting paid to you, they get paid. The harder one is what they call a copyright strike. Copyright strike, just like in baseball or anything else, it's bad because the copyright says the content ID, the content owner, or the copyright owner says, I don't like what Mr. Vera did. Take down his video and give him a strike. So if I get the rule is if you get 3 strikes, they take down your channel. So claim good, not so good, strike bad. So if those who have copyright strikes, there are certain ways to do it. Just follow the YouTube's instructions. But because I'm a copyright lawyer and IP lawyer, I myself do not use anybody else's work unless it's, if you see in my Bar Boys video, unless it's another YouTube video. So YouTube has this license saying that if you post it up in YouTube, your video in YouTube can be part of somebody else's YouTube video. So that's a tip I can give you. If you want to do a reaction video, a react video, or comment video, don't use a downloaded MP4 video. Use what was in YouTube. There's programs out there that you can use. You can research about it, which I did. So I recorded the YouTube video itself. I made sure it's the YouTube's frame, and I commented on that. So it's fair use because I used, even if it's not fair use, I'm allowed to do that because it's their YouTube video. I didn't get it from a MP4 or a downloaded file. I used what they put up in YouTube. So that's allowed, right? Okay, let's see. We have a question from Game. So the musical arranger should be first recognized in the contract as part of the production rather than outsource staff to demand remuneration rights. Okay. I work with a production company. They do a lot of music for advertising, and in their contracts, they make sure that they get paid first. They get paid well first, and they list themselves as the author. So, if you want to make sure that the arranger is recognized in the contract, then go put that in the contract. Make sure that you have it. If you are a musical arranger, make sure you're recognized in that contract. All right. Merlot again. Let's see here. Uh, is it true that if a song's melody has some similarity to another song, is it okay as long as there's not 4 to 8 bars or measures or melodic? Okay, John, there is no rule on how much the music. None. For example, uh, it's always my example to my students. The theme of Jaws, 2 or 3 notes. You already know it's the Jaws theme. Doesn't take that much. If I use that 3 notes, then it's not my work. Also, the first 5 notes of the Star Wars theme music. If I play the first 5 notes, you know it's Star Wars. There is no similarity. There could be similarity. In fact, it's ongoing. It's the last maybe 10, 25 years already. The common 4 songs of every pop song is the 1, the 4th, the 5th, and the minor 6th. Um, I think that's in an 80% of all pop songs. Every derivative of that is if you just YouTube it, the four most common chords in music. And is there similarities? Yes. Is there a lawsuit about it? It all depends. It's really it's subjective actually. All right. Hello, William, my son's good friend. As a wedding videographer, if a client requests music without discovered, is it allowed on IP law? No, sorry. It's touchy. It's a very it's a very touchy subject. So if you use somebody else's work and you put it up, if you put it in a video that is going to be for private viewing, it's allowed. If it's going to be published in YouTube, here's 2 things, William. All right. If the music is live in the wedding, meaning it's part of the wedding, if you didn't video it, then it's not technically infringing because it is performed in a circle of friends and family. That's what the law says. So if it's played in a wedding, it's not itself infringing. If you video it and it's part of the wedding, and that piece is put in YouTube, it all depends on the owner of that song. Are they very aggressive? I mean, I tell you, the aggressive ones are AC/DC, all the heavy metal stuff. Well, because that's all I know. Go heavy metal. AC/DC, Black Sabbath. You know, they're very. I think Queen. They're very. If they hear that, well, it's actually not the band per se. It's the record companies. And so again, back to William. So if you put up in YouTube, it's there in YouTube. I would recommend that it be a private listing and only those that have links to the YouTube video, they can view it. If it's a public viewing, then it might be subject to either copyright claim or copyright strike. So you as a videographer, if it's in your YouTube channel, then you have to defend that decision of doing so. But if you use it as background, maybe you choose to be a background of the video that had no music in the beginning, then that might be subject to. It all depends who they get copyright claim or copyright strike. Sony Music is very aggressive. That's what I know from experience. All right. So hopefully that answers your question, William. If not, just PM me directly and we'll talk about it. Frog in the chair. All right. Good evening. Is there any time limit when you're allowed to someone's copyright? No time limit. You know, even if it's 2 notes. If it's my song, let's say for me it's somebody else's song. I used to do 2 notes about it, and it's recognizable as that song. As I said, the Jaws theme, the Star Wars theme. If that's or the first, the Pretty Woman, the first 3 notes or the first 6 notes, you recognize it. So, is it time limit? No. If it's about content, no. Those videos are not accurate. There's no 6-second rule, 8-second rule. Nope. As I said, all it takes, if the content ID will recognize it, then it's there. Some songs take a while to be recognized. Maybe that's what it is, but there is no rule. Don't believe those videos. Don't believe those videos. William, I haven't seen many others comment. Sorry, I'm an industry where using music made by others is common and would like to know if the legality is using other people's without permission. Okay, as I said, William, if it's live in the wedding and you video it and you put it on YouTube publicly, there might be a content claim or a content. It's not a copyright strike because it's not the actual work. But if you use the actual, MP3 file or actual music, then there might be some legalities there. So my if but if it's or if it's played as a background in over a speaker, it might. I mean, I can't. It's hard to accept, William, but it all depends on the owner of the music. I mean, I know a local artist who works with Sony, and Sony is very aggressive in getting those things. John, there have been any YouTube channels that upload entire albums of singers. Is it infringement? Yes. Why this very strict claims and strikes, but seems to be part of entire albums? Well, it's really, we don't know. For example, let's say I am ACDC, and I know Mr. Sports Law YouTube channel plays my music. Uh, the content ID will tell me because I have to make the copyright strike or claim. It's up to me. Uh, if it's an entire album and there's a lot of views and it's just the album, the music, without anything else, I may let it go because it might generate more sales for me. But if it's part of your own content and you're monetizing it, then the band might go after you. So it's a touch and go situation. Uh, William. Oh, thank you very much, William. I really appreciate it. Hopefully, she'll take a blow. Okay. All right. John, if a songwriter goes to court for claiming his melody was copied, is the judge who also listen and make an oral comparison? Yes, I'm afraid so. It's really, um, but the judge itself will not do it. He will, of course, ask experts. So there'll be experts to testify, but the judge itself will determine whether. Well, if he himself will listen, well, if he's a musician, then he will know. But not all judges are musicians. But expert testimony will be brought forward, and it may happen. But yes, so far as deciding whether it's infringement, that's the judge's determination. 1485 bot. You're late. Good evening. Well, welcome. Aha! Ms. Ramin, good evening. What about songs in Spotify? Does it violate copyright law? No, it does not, because Spotify works with the record companies. So whether they get paid enough, that's another question. But Spotify is not. Spotify is totally legal because Spotify will not put up a song in their library that they only do it with authorized music. They won't do any. They work with the record companies. They do pay a fee, not much, but you know, um, that's the reality of it. All right. What are my thoughts on record companies? We need them. They're smart. They had smart lawyers, um, but it's the yin and yang. You both need each other to work. But in today's digital age, not necessarily. Uh, for the for the price, if you my son will get angry. If you save up your Starbucks money for the year, you can record your own songs at home. That's my tip. You can actually do that very well. You just need to have a good mic. For example, for me to record the keyboard or the guitar, I have a mic. I just have to buy a simple audio interface, connect to my computer, put it in a. There are free programs for it, and record it, mix it, and then put it up in YouTube. And so I know. my client recorded their last album separately at home, and they just mix it all together. So especially now during the pandemic, a lot of people, a lot of bands have recorded or put up their music, even solo artists, on their own, and they publish it on their own. Okay, we got 20 minutes till 9 o'clock. I will end this live stream at 9. So it won't take too much of your time. Oh, we have another question. Okay, Mr. Gonzales. Is it legal for artists to take some samples of their own of other songs and put in their own? For example, some part of Frank Ocean's Close to You and put it in Stevie Wonder's Close to You. Okay, is it legal? By itself, no, Raphael. Although there is a doctrine called transformative, not the Autobots or the Decepticons, not that. Meaning, if you take somebody else's music or sampling and transform it enough, it is still recognizable as the root song, and transform it into another work, a new song, but it's so changed that it by itself is technically a new song, then under that condition, the U.S. courts have determined that it is transformative enough to be exempt from infringement. But that's determinative of the judge and whatever experts are there. One of the you're showing your age because of the Frank Oceans, but during my time, the most famous sampling, illegal sampling, was Ice Ice Baby and Queen's Under Pressure. The bass line of John Deacon, so known to be under pressure, but it was put into Vanilla Ice's song, and it wasn't transformative enough, meaning it was still recognizable as a Queen song. Right. Mr. Ignacio, Angeline, I'm sorry. Good evening. How about sampling musical conditions? Do you foresee it will be considered as copyright infringement here? Sorry. Good evening, Dean. How about sampling in music compositions? Do you foresee that it will be considered as copyright infringement here, or do we have existing jurisprudence on this matter? Well, I'll answer the question in reverse. Is it jurisprudence? No, we do not have any sampling jurisprudence yet. Do you foresee there be infringement? Yes. Do we have sampling in music compositions? Yes. Why do we consider it will be infringement? The reality of it, Miss Angeline, that record companies that usually own the music are very aggressive in protecting their investment, if you will. And if somebody is sampling without permission, then they will go after that. I'd like to talk about something. If you, what's his name? Forgot this artist who sung on the Wish Bus. Forgot his name. And what was his name? I forget. Anyway, he's based in the US. He's a rapper. And he made a song which had all these languages, all the dialects. He did say a historical flaw on how Lapu Lapu died. My thoughts on that is, of course, I tweeted about it and I put it in my Facebook. It is the National Historic Commission has no business in telling what artists what to sing. No? For example, this is brought up to my friends in Facebook. The song Africa by Toto. Do you think the Africans should go after that because of its inaccuracy? No, right? If I were, any artistic interpretation of anything, whether it's true or not, should be left alone to the artist. The government, through the Historical Commission, should not tell us how we should sing. Right? All right. I will go out on a limb here. Okay, I'm gonna skirt the issues here. I'm gonna touch the plane. The national anthem in the U.S. people can sing. They want to sing the national anthem, the Star Spangled Banner. Uh, People can sing it wildly. They sing it funny, uh, comedy, comedy wise, and all that. Some people have used the guitar to play it. Joe Satriani, and the most famous one in Woodstock was Jimi Hendrix playing the Star Spangled Banner. And those are artistic representations of a work that is public domain. And so is our national anthem. It is public domain. Anybody should sing it the way they can. A few years ago, if you remember, there was this Americanized Filipino American singer that sang it in abroad, in America, and he sang it in his own version, and people here got angry at him. And for me, I said, why? First of all, he sang it in America. So we're not, the Philippine law don't apply. It doesn't apply there. Secondly, freedom of expression outweighs any law, even if it's the national anthem. Well, that's my view. Hopefully, I know maybe some will disagree with it, but if you can put the flag in shorts, if you can put the flag in a cape, if you can put the flag on your shirt, and I think you can sing the anthem in your own way. Okay. Let's see any questions. So that's my take. Any other recent IP issues? Let's see here. One case here, which was given. Let's see here. Let's go back to the case list. Right. All right. So we talk about moral rights already. Okay, amended, right? Okay. All right, let's. Oh, here we go. Frog. Let's see here. What's the question? If the creators broke up, Daft Punk, yeah, just imagine. Can the music company still attack you? Oh, all right. Now, rights are created the moment the song was created, and if those rights will exist even after the death of the creator. As I said, copyright survives for 50 years after the death. So whether a group broke up, it doesn't necessarily mean that their rights have broken up. If Daft Punk, I'm sure, owns still their rights, and since there are two of them and they split, so if ever any royalties that come from the record company or publishing company, they would get both. They will still get their share. I'm sure they were given checks individually for their music, and it will continue till forever until 50 years after they pass away. So if they break up, it's just also the record company or publishing company will just split the check as well, if there's any agreement to that. All right, John, thank you very much. Sana dumaming IP lawyers. Yes, I do. Just remember, John, I am lawyer for the artists. That's what I've been for the last 15 years. And I told you, I work with the Performers' Rights Society of the Philippines. I work with the Movie Actors Guild, the Mole Fund, and photographers. I do work with a lot of photographers as well. In fact, I did file many years ago a case against a newspaper. My client's pictures were downloaded from his blog site, and the newspaper used his photo. We went to sue the newspaper. Unfortunately, the case was settled, but nevertheless, I went up against a big newspaper. All right. Miss Ubalde, there are YT channels that are merely compiling clips of streams to other streamers and uploading as their own. Would that constitute as transformative content? I would say no. As I said a while ago, Miss Ubalde, for example, let's say John, Angeline, and Miss Ubalde. Okay, if you guys have YouTube videos in your channel, technically under the YouTube license, I can get your videos, take 10 seconds out of it, and make my own video. Whether it's transformative enough or it's changed enough, it doesn't matter, because YouTube's license, or you give a license for other YouTube users to use your content as long as it is originally your YouTube video. Fortunately, if people do that, yes, are they cheating? Yes. Are they making money? They could. Is it fair? Well, you could do it yourself. So then if you take revenge on that. But sorry to say, YouTube allows that. Um, so if somebody out there, in some dark corner of the world, takes my videos in YouTube, because I don't have any videos in YouTube, and they make their own stuff, and it's put in YouTube, I can't do anything about it. But if it's put up in Facebook, then I can go after that. So if the platform changes, then there is infringement. Is it transformative? It doesn't matter. If you use 10 seconds of my video, I will still go after you in Facebook. That's what the law allows, right? So it's transformative. I don't think so. Okay, it's been 50 years since songwriter's death, but his song was tied to a perpetual publishing contract. No, 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 no. If it's this country and the singer has passed away 50 years ago, so if it's 2021, it's 1971. So any song that was written in 1970. Oh, so if a author passed away in 1970, then his songs under this country are now public domain. It doesn't matter the contract. It does if it's perpetual or what. The rights are lost, and just an example, those rights are lost 50 years. So anything, well, sorry, I sort of say any person who has any author or composer that has gone to heaven in 1970, 50 years, yes, 30, 50, 90, now 51 years, their songs are now public domain. It doesn't matter how the contract is. But there's a twist. If it's a Philippine contract, Philippine artist, it's 50 years. But if it's a US contract, it's 75. I'm sorry. All right. So game. So no effort of government standardization, especially the national anthem, which is not authorized, should be artistic expression. Okay, game. This is kind of touchy here. As I said, if the song is owned by the government has no copyright. They don't own the copyright. Can they make money out of it? If the copyright exists. The national anthem was composed hundreds of years ago. Therefore, there's no copyright on the national anthem. So, by law, we can sing the way we want. Is it standardized? That's much my view. I believe in people's freedom of expression as a lawyer for the artist, and I think that everybody has their own right to express the national anthem. Is there a government standardization? It can't. Well, here's the thing. I read the law, the flag law, and it said that everybody should sing it in its original composition in Spanish. We have to sing a national anthem originally because it was originally composed in Spanish and it was a marching song. So let's do that. Good evening, Chavez. Mr. Chavez, good evening. All right. Okay. Okay. We have 7 minutes for this live stream. Is there anything else you could ask? Please go ahead. We can do some rapid questions. I'll be happy to answer them. If you have any, let's touch on it. If you have any questions on trademark, maybe or patent, the last few minutes I can answer that if I can, and not just copyright. I will eventually have a live stream on trademarks and patent law, but we'll schedule that. The next live stream will be again back to a law school Q&A. What I'll do is I will answer all the comments I've had as questions, and I will start with that so that whoever listening can also benefit from other people's questions, and we can go from there. All right. Okay. If maybe we can do this already. Again, so to those artists listening, to those musicians, and or maybe record companies, just know that the law on copyright is meant to protect the rights, not to eliminate it, not to restrict it. Rights always should be interpreted for what they are. The copyright are about artistic and literal works that give us enjoyment, give us, no matter how awful it is. Uh, and the law should that's why IP law was made, because by creating a legal framework where an artist, a creator, an author can make something out of his talents, out of his hard work, and he can make money out of it, and at the same time we enjoy his work. I mean, we enjoy the music of Led Zeppelin, of Van Halen. We enjoy the works of Taylor Swift. We enjoy the works of Lady Gaga. I mean, if without copyright protection, we will not have these artists make the songs, make the movies, because they know by making these movies, making these songs, they know that the government, through a legal framework of intellectual property laws, will protect them. I mean, if movie companies know that there is no legal, it's not the government will protect them, but the government creates a legal framework for protection, then they will make more movies. Singers will make more songs. Artists will make more paintings. Laureates will make more poems. Without knowing that they'll be protected, they will cease to do it. I mean, any right person knowing that if there's no protection, if I can make money out of it, might as well not do it. That's the essence of copyright law, intellectual law, or rather. Okay. All right. I wish everybody a good evening. Thank you for staying with me for this couple of hours. I do hope that you'll have a good week this week. It's March 7, 2021. For those in the Philippines, please stay safe. It's still out there. That's why I'm doing this, so you can stay home, stay safe, and make sure that you do all the protocols, follow all the social distancing, and please take care of yourselves so that you can still watch my videos as I make them. Okay. Your game. I will do my best to make another one, maybe in a couple of weeks. So I have to do more lives in other aspects of law, but definitely there'll be another one in copyright, and maybe we can do a more structured ways that I will invite first questions before I make the video, so at least I have a set of questions from our viewers and subscribers. Again, thank you very much. If you haven't subscribed to the channel, please do. I appreciate it very much. It helps me quite a lot. If you want to go back to this video, I think in a couple of hours or for tomorrow for sure, this will be uploaded or put in YouTube as part of my channel. The video is part of my channel, so you can get to watch, so you can skip and see what questions are there. Sherwin, you're very welcome. Mr. Balde, thank you. You're very welcome also. Okay, I wish you all a good night. Stay safe and God bless. Bye-bye.